side will have 15 minutes. The appellant may reserve some time for rebuttal. And if you wish to do so, please let me know how many minutes you would like to reserve.
Thank you. Good morning. May it please the court. My name is Leslie Grasky, and I'm here today on behalf of Patrick Mullen, the husband in this matter. I have good news as to assignment of error one. One is that...
Do you wish to reserve any time?
Oh, I'm sorry, I do. I wish to reserve 5 minutes.
5
Thank you.
minutes, thank you.
And I'll return to the good news as to assignment one, which is it is moot. And it is moot because the wife had the jewelry and the husband did not have the jewelry, so there was no good reason for his property to be ordered, held by wife as hostage. As to assignment of error number 2, we believe that the trial court erred in awarding spousal support on an equalization of income basis without taking into account the very substantial debt which was assigned to husband and which is in his sole name. That is a parent plus loan which has a principal balance of $30-some thousand, but it will require payment of $75,000 to be paid in full.
How do we tell from the record that that was not considered?
You can tell because it's not assigned, it's not divided between the parties. Wife is not.
Well, could it also be that it was considered and the court thought that was the equitable way to deal with the debt and the support issue?
Well, the problem with that, Your Honor, is that the court then used a formula to equalize the income. So a payment which was currently $235 and which would go up to $400 per month makes it so that the husband has substantially less income on a monthly basis than wife. So it doesn't seem like the court considered that.
So is the failure to consider not so much about the debt, but failure to consider the fact that the debt payment was going to increase?
I believe that would be a correct statement. I think having $75,000 of debt is a significant consideration under 3105.18CI, which says the court can look at the assets and liabilities of the parties, including court-ordered payments. And that's a fairly substantial difference when you look at these two people's income. I think equalizing was particularly troublesome in light of the fact that this known debt can't be used in the future as it increases in cost to modify spousal support, because Mandelbaum would say you knew it was going up at the time of the decree. The further problem with the spousal support order is the wife only testified that she is working part-time due to a medical issue, which is CMT. It's a tooth disease. She brought in no medical evidence of a diagnosis. She brought in no medical expert. There was not a vocational assessment, and there wasn't even extensive testimony about her actual inability to work full-time. And if her income was raised from $19,600 part-time to full-time, that would also make a difference if you were allocating all of this debt to the husband. Recall that the husband had paid for all of the fees, all the attorney's fees, and the trustee's redemption of the party's tax exemption when they filed for bankruptcy, so that all of the other debt that could have been considered had been removed only at husband's expense. The trial court properly ordered $1,300 a month on a temporary basis. It was error for the court to increase that by $500 at the same time the husband would have the debt, which would climb from $235 to $404. The spousal support error was compounded by a requirement of life insurance. The decree specifically states that support would terminate on the death of either party. When the court then added a life insurance component, this negates the finding that this is a lifetime spousal support order.
Don't understand that.
Okay. If you have life,
If you have life insurance and you die, the
Yeah.
life insurance then will substitute for the spousal support.
right, and
Okay, so what's wrong with that?
what's wrong with it is two things. The court expressly terminated his spousal support obligation on his death, and it wasn't life insurance just to cover any arrearage that might exist. The courts have recognized that, and this court fairly recently in Stickney versus Stickney found that if it is a spousal support obligation terminable on death, the trial court cannot impose a life insurance obligation.
Now I understand, thank you.
Thank you.
Is it, with the, back to that, requirement of life insurance, naming the wife as irrevocable beneficiary in amount sufficient to satisfy his obligation of spousal support? I'm not exactly sure how you go and get life insurance in an amount sufficient to satisfy a spousal support obligation.
That's a similar and related issue. In fairness, I'll tell you, you could say you have to buy insurance and wife needs to be the beneficiary to the extent of her interest in it. I mean, that's how you do with real estate mortgages. You know, I think that could have been drafted around, but
And the reason why I asked the question is because we have this termination at death, and I'm wondering how the amount of spousal support that was ordered, ordered and then ordered to be insured.
right.
I'm aware of Stickney, obviously, so I understand where that comes from, but I'm just kind of trying to figure out if there is something different about this particular order and the manner in which it was drafted that.
Nothing that I could find. You know, I worked on both cases, so I was looking at the parallels at the time I was drafting briefs, and I can't see any basis, at least in Stickney, there was a substantial debt that the wife was going to have to pay without spousal support. You could make some argument that this is why that would exist. Other cases, there's an arrearage in spousal support. You could understand securing that, but there is nothing in this matter that would justify imposing a further obligation on this man to maintain life insurance on a spousal support obligation terminable at death.
But he did in fact have arrearages. It was only $3,600, but he did in fact have arrearages at the time of the decree.
Yes, Your Honor. I believe the full language imposes an obligation above and beyond what was authorized by statute and what was ordered by the court.
What was the cost of the life insurance?
No, I cannot recall, I'm sorry. Thank you.
Well, you have 7 minutes left. All right. You'll only get 5.
I understand.
All right, thank you.
Thank you, May it please the court. My name is Attorney Brian Ashton. I'm representing Bethanne Mullen, who's the appellee in this matter. Given that appellate counsel has skipped issue 1, I will do the same as well. I guess since we're currently focusing on the life insurance issue, I would start there as myself. There was arrearages in this case. I do believe that this court has laid out particular language stating that life insurance is appropriate to order if there was arrearages in this case. Therefore, our position is the court did not err. However, we do understand that that specific language might have needed to be included in the final order.
That it might have needed to say an amount sufficient to satisfy the arrearage.
I do believe so. Honestly, I wish I could come out here and say, yeah, he needs to get $2 million life insurance policy or whatnot. But in my research and my conclusion, I do believe that specific language probably did need to be included in the final order. I think that would satisfy all the case law that's been presented in front of this court. In regards to issue number 2,
Excuse me,
Sure.
can that be implied?
I'm sorry.
Can that be implied since the purpose is to ensure the arrearages?
Yeah, I think it has to be. My law partner and I were sitting around having breakfast this morning talking about that and the challenges with that though too. Because arrearages today might be $3,600. If he didn't pay spousal support for the next 10 years, then, you know, the rearages could be a fortune. And so, yeah, I think that burden does become on him to make sure that his life insurance is sufficient to cover whatever said amount would be.
Well, here's a question though.
Yeah.
It does say, husband shall maintain life insurance during the pendency of a support obligation. And this is indefinite, there's no time frame on this, and this is for life.
Right.
So a husband walks out the door of the court and dies on High Street. His life is over, he has no obligation, his life, it ended. The
Correct.
day he died, it ended.
Yes.
So, but in this case, say he lives another 100 years, and he owed $3,600, and even if he doesn't pay during that next 100 years, there's judgments that are made throughout that period of time. When he does pass away, there's judgment that could be taken against his estate.
Correct.
I would presume, if the
Yeah.
estate's insolvent, there would be, presumably, he would have gone to jail and contempt many times in the meantime, but nonetheless, I mean, it seems to me that there's other ways of getting that spousal support obligation satisfied during the pendency of his life without life insurance, whether it's $600.
I would agree. I certainly agree that there could be actions taken within probate court following his death, and a claim could be made. But I also feel that this court has soundly ruled on this issue as well, saying that it is possible through the DR court as well, too. And collection obviously becomes an issue. Do you collect through DR or through probate? I think my initial thought would be through probate ultimately anyway.
Well,
So,
but you get a judgment in the DR court,
Yeah.
you could attach a lien to a piece of property while
Sure.
it's living. There's ways of getting,
Yes,
there's bank accounts, there's all kinds of things you can.
correct. So did I answer your question, Your Honor? Okay, good. So I will move on to the second issue at hand here. First, I wanted to start with Ms. Mullen's work, part-time work schedule. We're not talking about someone working 5 hours a week. It was clear in the testimony she's working 32 to 36 hours between two jobs. There was no issue at the time of the trial as far as concerns or her lack of a desire to work. In fact, she was very clear in the transcript she enjoys her job, she's wanting to work. The truth of the matter and the reality of the circumstances is she's a woman that put aside her career to raise her family. She's now starting said career later in life than what can be expected. She does suffer some aches, some pains. She has a labor-intensive job as a home health care aide that can be physically demanding at times. She is engaging in it the best she can. It's not like it's someone that's just working 2 hours a week and saying, the rest I'll make him pay. She's avidly and intentionally working. She also has a retirement to consider and working hard. That being said, that's why I think the student loan was ordered the way it was. He had been working the majority of his adult life. His earning potential was much greater. He had made much more income throughout the years. He had supported the family. She is now currently engaging in a new job. He has a current job. He has benefits through that job. He had overtime. We know that at some point he had overtime. There's dispute at the trial time. He did or did not. He also had work bonuses through work. I think that the division was equitable. And then the main issue here is did the court abuse its discretion? The court heard testimony from both parties. It made its decision. It took into consideration the appearance, their voice, their demeanor, everything a trial court should do in this case. It came up with the conclusion that he had to pay the student loan amount. It was fair, it was equitable, and there's other considerations at hand. Like I said, she is now earning retirement. She has to pay for her own apartment. She's starting over, and I think this was a fair and equitable settlement of the case. And if there's not any more questions, I think that concludes all my thoughts. Thank you.
And you have your 5 minutes.
Thank you very much. I have the decree before me at this point, and it reflects that husband shall pay and indemnify and hold wife harmless on the debt to Sally Mae. I wanted to make clear that all of that is there. Having already bankrupted and paid the expenses for both to be otherwise loan-free. Husband is also ordered to pay on an arrearage of $3,600, and statutory interest was granted. So the wife was protected in that regard. The order expressly intended to cover the remainder of the $3,600 arrearage. If that's what the court meant, that would be potentially a livable solution, but this is not that. It says his spousal support obligation, and that's an obligation that terminates upon his death. We would ask that the court remove the obligation of life insurance. I don't think there was any accusation that the wife is engaging in bad faith, but when you're claiming that your inability to work is based on a medical condition, it seems that it would behoove you to present some evidence in that regard. And it's the combination of the factors that makes the spousal support award inappropriate. If he were not paying the student loan that was made during the marriage with both parties' consent, then equalizing income would not be so burdensome if the wife were working full-time, or if she were diagnosed. It was actually, she hadn't completed the testing. There's testimony in the record that she had not done that, she had not been diagnosed. She just came in and said, I can't do this because I don't feel good. And given all of those factors,